In a pretrial deposition, in a medical malpractice case, in an accident case, or even a wrongful death case, are there trick questions that the defense attorney will try and ask the injured patient, the injured victim, or the surviving spouse? Would you like to know the answer? Come join me for a walk around the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes, and then again, the answer is also no. Now, there are no trick questions in these depositions. Many injured patients, many injured victims think, okay, when I go ahead and give my testimony in this pretrial question and answer session, I know that the defense attorney is out to get me. I know that anything I say can and will be used against me when I get to court. And that is true. Anything you say during your deposition will be used against you, especially if you contradict something that's already in a particular medical record or in a different record. Now, what do I mean? Let's say this is a medical malpractice case. And now, while you're being treated by a particular doctor, you have no contemplation that you're going to be bringing a lawsuit. You have no inclination that you're going to suffer injury. And now you are being totally honest with the doctor. And now the doctor asks for your history. What medical issues and what medical problems have you had in the past? What medications have you been taking? What problems or complaints have you had in the past? And what type of treatment and surgery? And they'll go through your entire history. And that gets recorded in your medical chart. Now, during the time of your deposition, many years, many months later, you will be asked questions about your medical history. And you're thinking in the back of your mind, oh, they're never going to find out about this procedure that you had done years earlier. There's no possible way. You had it done by a doctor who was out of town. You had it done in a place that no one's ever going to learn about. And you know what? You don't think it has anything whatsoever to do with the particular complaints that you're making against this particular doctor in your case. So now when you are asked the question about your medical history, you omit certain things about your medical history. You are not actively saying they didn't happen, you're just not including them. And now the attorney persists, and the attorney says, is there anything else that you have in your medical history that you haven't told me about? And now you're thinking in your mind, do I tell him, do I not tell him? You decide, no, there's no way he's ever going to find out. So you decide not to disclose that information when you are being questioned during the time of your deposition. So now, why did I ask the question in the title of this video, are there any trick questions? The reason is because before you get to your deposition, the defense attorneys who will be questioning you, they will already have had an opportunity to review all of your medical records, because we have an obligation to provide the defense with copies of your medical records, and we are also required to provide the defense with permission slips that we call authorizations that will allow the defense to get your medical records directly from the various doctors and hospitals where you were treated. And your perception that they would never find out about a particular doctor that you were treated from is likely incorrect, especially if you had insurance that paid for that doctor's visit. They will ask for your health insurance records, and they will scour those insurance records, and then they will ask us for permission slips to get pretty much every single doctor on that list. So your perception thinking, no, they're never going to find out. Well, guess what? Now when they ask you that question at the time of deposition, hey, were you ever treated by any other doctor for this particular problem? Hey, did you ever have this type of problem before? And you're thinking, no, absolutely not. They're never going to find out. So you not only omit that information, but now when you're asked a direct question whether you ever had a condition like that, you're like, absolutely not. Guess what? You've now screwed yourself. Why? Because you have now contradicted something that's in your medical record. Now, in all likelihood, if you had discussed this with your attorney and told them about any concerns you had about that particular medical condition, as well as whatever may be contained in that doctor's record that discusses that, guess what? Your attorney would have been able to talk to you about it and in all likelihood told you to go ahead and discuss it and answer that. Why? Because it probably has absolutely nothing whatsoever to do with the claims that you're making in this particular case. And it likely has nothing whatsoever to do with the damages and the injuries you are claiming in this particular case. But because you have intentionally omitted that information And now you clearly denied when you're asked a direct question whether you ever suffered this particular complication. You have dug a hole for yourself that may be difficult to get out of. And you're thinking, okay, it's a simple contradiction, can I explain it away? And the answer is yes, you probably can explain it away when you get to trial. And you're asked this question, and now the defense shows the jury that you have contradicted yourself. And they will argue to the jury at the end of your case that if this injured patient, this injured plaintiff, has lied about something so simple, so insignificant, how can you really believe anything he said about the key issues and the key details in this particular case? And in law, there's a Latin phrase for that. It's called falsus in uno. And the defense will ask the judge to give the jury a legal instruction at the end of the case that basically says, if you find that a witness has lied about one thing, you have the legal right to go ahead and disregard some or all of their testimony. So that can create a huge problem for you if it really is insignificant. And the question that I have is, why? Why would you go ahead and do that? There's no reason for you to do that, even if you think it's damaging. When you go ahead and bring a lawsuit seeking money as a form of compensation for all the harms and damages and losses that you suffered, your life becomes an open book. Your medical conditions become an open book. And if you somehow think that something in your past, your medical history, is not going to be learned or disclosed, guess what? You are mistaken. And it is much better. It is a much better strategy for you to go ahead and disclose that information, no matter how private a person you are, to the defense, so that there's no issue later on about your credibility, so that there's no way that they can contradict something that you said a year earlier in your pretrial testimony. You don't want to go there if you don't have to. Let the medical experts fight about the basis of this case, about who's more right than wrong. But your credibility should not be an issue here. And if you go ahead and answer these questions, these pretrial questions, in a way that is designed to leave out critical information, and in a way that denies certain information that the defense already knows is incorrect, now you've trapped yourself. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I recognize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.